Hi, I'm firearms attorney Gilbert Ambler, and today we are going to talk about the trap that is the Federal Gun-Free School Zones Act. What we're going to talk about what this law covers. We're going to talk about the exceptions to this law that commonly affect most of us on a day-to-day basis, as well as why those exceptions are so narrowly construed that at times they are, in fact, a trap for the unknowing. And then we're going to talk about a case that could break open the constitutionality of the Federal Gun-Free School Zones Act. But before we dive into all of that, if you have not yet hit that subscribe button, go ahead, hit subscribe, like, comment, tell us your thoughts on this video, and share. That way you and your friends can keep getting this important Second Amendment related content. All right, the Federal Gun-Free School Zones Act. This was a law originally passed in the 1990s, and in fact, the original version of this law had its constitutionality successfully challenged. And in that challenge, it was a challenge to the power of Congress to enact this law. The law generally bans firearms within 1,000 feet of school property. Now notice, I said school property, not school buildings. School property. Loaded firearms generally prohibited within 1,000 feet of school property. And this includes public roads, it includes public sidewalks, it includes the areas that many people might not realize firearms are generally prohibited because we don't think about schools that way. We know guns are generally prohibited inside school buildings, but 1,000 feet away from school property, including those public roads, also firearms generally prohibited by the Gun-Free School Zones Act. Now, when Congress passed this law, they passed it as an exercise of their commerce power. And this is important because Congress, generally speaking, the federal government, has the power to regulate or to pass laws under one of two legal theories. The first would be the power to tax, but this is clearly not a tax, this is a criminal provision, or the power to regulate interstate commerce. And so the law was originally challenged, saying, hey, this ban on firearms in school zones is unrelated to interstate commerce, and the Supreme Court actually struck down the law, saying, you're right. There is no relation to interstate commerce in this ban. So then Congress repassed the law, and when they repassed it, they narrowed it so that it only applied to firearms that had traveled in interstate commerce. But of course, that's virtually that have traveled in or affect interstate commerce. And of course, that is virtually every firearm out there has traveled. A gun manufactured in, say, Arizona gets sent to Virginia. It's traveled in interstate commerce. Congress now says that they have the power to regulate that firearm. Of course, many lawyers think that this power to regulate commerce has been extended and overextended far too much, but that's a story for a different day. We need to understand this Federal Gun-Free School Zones Act. So, general ban on firearms within 1,000 feet of school property, okay, including public sidewalks, public streets. However, there are multiple exceptions to this prohibition. There are exceptions for private property. So, if you're a homeowner within 1,000 feet of school property and you're on private land, there's an exception in the Federal Gun-Free School Zones Act. There's exceptions for law enforcement. There's exceptions for those traveling or passing within the 1,000-foot zone if the firearm is both not loaded and locked up. And that's important, not loaded and locked up. So it's not enough just to unload the firearm to meet an exception. It has to also be locked up to fall under this exception. Or probably the biggest exception, the one that affects most people on a day-to-day basis, is if they have a license or permit to carry the firearm that is issued by the state that the school lies in. So here in Virginia, if you've got a Virginia concealed handgun permit and you're going within 1,000 feet of a Virginia school property, you have an exception under the Federal Gun-Free School Zones Act because you have a permit issued by the state that the school lies in. Now, notably, this exception does not allow you to travel on school property. Of course, there are other Virginia state level laws about guns on school property. This is an exception to that 1,000-foot zone. We're talking about passing on public streets, public sidewalks. You still always have to check the state laws as well. The issue with this is that it does not necessarily cover those who might be carrying in either a constitutional carry state or those who might be carrying with reciprocity. For example, let's say you have a Pennsylvania license to carry. Virginia recognizes that provided you're over the age of 21 and you've never had a Virginia concealed handgun permit in the past and had it revoked. So you come from Pennsylvania, you're driving through Virginia, and you drive past an elementary school on public streets within 1,000 feet of the school. Technically, you are probably in violation of the Gun-Free School Zones Act, because although Virginia recognizes your Pennsylvania license to carry, it was not, this is a Virginia school and you're passing by the school without having a license actually issued by Virginia. Even though Virginia recognizes it, wasn't issued by Virginia. Technically, that's a violation of the Gun-Free School Zones Act. Now, there have been, and it's worth noting, there have been law review articles that have argued that by accepting the Pennsylvania license, Virginia is essentially adopting it and therefore issuing it, but it's a somewhat weak argument and probably violates the clear letter of the law, the Gun-Free School Zones Act. Here's where things start to get interesting, because prosecutors have not charged a lot of Gun-Free School Zone Act violations in and of themselves. Sometimes it gets charged if somebody like a felon is caught in a school zone, or if somebody's doing something nefarious inside a school zone and they have a firearm. Often this is an add-on charge. It gets charged in addition to something else, but rarely charged as a standalone offense. However, recently there was a case in Montana where a Montana man had multiple calls to the authorities complaining about him walking on public sidewalks near a school while carrying a firearm, and apparently he must not have a Montana concealed carry license or permit because the feds decided to prosecute him under the federal Gun-Free School Zones Act. And in doing so, because he's not a felon, it doesn't appear that he's otherwise prohibited from possessing the firearm, they are virtually guaranteeing that his defense attorney is going to challenge the constitutionality of the Gun-Free School Zones Act. And of course, it's a Second Amendment challenge under the rules as set forth in Brune. And remember, this is public sidewalk outside of a school. This is not the school itself. So I don't think the government is going to be able to get away with saying, well, let's point to the dicta from Heller, the dicta from Brune that says a school is a sensitive area. I don't think they're going to be able to succeed on that, because this is not, in fact, a school. This is a public sidewalk near a school within that 1,000 feet zone. And I think it's going to make for a very, very interesting constitutional challenge. And I think if the court faithfully applies the Brune test, what they will find is there were no analogous founding era laws that restricted firearms within 1,000 feet of a school, let alone any other property. This sort of, how close can you get without actually being in the property? Kind of a ridiculous modern invention. So stay tuned, keep an eye on this case, and if you enjoyed this content, go ahead, hit that subscribe button for us. Until next time.